one. All right. Hello. Hello and welcome. Hello and welcome. Thank you all so much for being here. Welcome to another episode of Deportation Defense Live. Today it's the 13th of December. It's Tuesday, the 13th of December of 2022. Thank you so much for being here. My name's Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And I'm grateful. I'm grateful for everybody for being here. Welcome to those of you on Facebook. Welcome on YouTube. Welcome on Instagram. Welcome on LinkedIn also. I love being here with each of you. All right. So this is Deportation Defense Live. Our theme today is motions. Motions in immigration court. How to use them. Okay. And so thanks to everybody that submitted your questions ahead of time. And we'll jump right in. We'll get started. Okay. So remember that Deportation Defense Live is here to train, teach, inspire, and empower immigrants who are facing deportation to make the most out of immigration laws, to make the most out of their lives, and to win their cases. All right? Are you facing removal in immigration court? Do you know someone who's facing removal in immigration court? Because if so, you know that it is not easy. All right? It is an uphill battle. The laws are against us. And here at the Deportation Defense Live, we're here to maximize your chances of winning that case. Got it? So today our theme is motions in immigration court and how to use them. And we've just received a couple of questions today. And so if you have a question as I'm going through, hey, send it over. I'd love to answer it. All right, that's part of the process. All right. So let me talk about the basics. Okay. Immigration court is court. All right. And as any court process, there are options with how you go through it, okay? And one option is a really bad option, and that one is kind of like the wait-and-see approach. You know, you just go through and you take whatever the judge gives you, and you take whatever hearing they give you, and whatever, you know, the procedural aspects of the case, and you just go through the steps that the normal process will take you through, all right? That's a very passive approach to immigration court processes, and I don't recommend going that way. People lose when they go that way, all right? The other option, kind of on the other hand, is you can ask the judge to handle certain aspects of the case the way you want it done, within reason, right? And the way to ask the court to do something outside of its normal process is by making a motion, right? A motion, quote unquote, a motion in court is basically just another word for a formal request, okay? So it's like, you know, I formally request that you reopen my closed case. That's called a motion to reopen. That's a big motion. You know, there are big motions and there are small motions. And examples of big motions include motions to reopen, because if you file this and you win it, you can reopen a deportation order against you to give yourself another shot at fighting a fight. All right, it's a big deal. Another big motion is a motion to terminate. If you file a motion to terminate and you win, your case is done. All right, there's no more, you're no longer subject to deportation proceedings. It's essentially like you won. Okay? And another big motion, example of a big motion, is a motion to suppress. If you file a motion to suppress and you win it, then either your whole case could be thrown out or certain evidence that was filed against you might be suppressed and thrown out. It can give you a lot of additional arguments and power in your case. They're not easy to win, though. All right? So yeah, there are big motions like those, but there's also small motions in immigration court. Okay? And a small motion, you know, hey, Your Honor, I formally request that we continue our next hearing. A motion to continue, those words, what is that? It's a request to move to a later date my next hearing, right? And why would you ask that? Well, imagine, hey, I have an important medical procedure happening on the date of my next hearing, and here's evidence of it, Judge, and so I formally request that you change the date of my hearing. Okay? Because I'm going to be in surgery or something. Okay? Like, people have the right to make those types of requests. You can file a motion to transfer venue. Judge, I don't live in Chicago anymore, for example. Now I live closer to San Francisco, so I formally request that you please transfer my case to the San Francisco Immigration Court so I don't have to drive all the way across the country to go to my next hearing. Right? It's called a motion to transfer venue. You can do a motion to advance. I don't know if you have heard of this, but motions to advance is like, hey, Judge, I've waited too long. Something bad is going to happen if I have to keep waiting longer. So I formally request a sooner hearing, a quicker hearing for XYZ reason. Got it? That can be powerful. We want a motion to advance a trial date and then won that trial just, 3 weeks ago. All right? It can be a game changer. Okay? So a motion to substitute counsel. Hey, what does that even mean, right? It's like, I have a new attorney. I want a new attorney to fight my case for me. I don't like my old attorney. So let me file a motion to substitute counsel so my new attorney can handle the case. Okay? And the truth is that your attorney will be able to file that motion. You don't have to file it. Your attorney can do these things. All right? Motion to appear by telephone or by WebEx because I can't attend in person. You can do that. Motion to amend something in the past. My prior attorney messed up, so I want to formally ask the court to allow me to amend or change some things in the record. These are just some ideas. All right. Human, did I just get a message from you? Great to see you. Great to see you. Reach out to me. I'd love to connect with you. I want to hear how you're doing. And I see some folks here on Instagram. Alex, Vinod, Arlene, Neira. Hello. Hello, everybody here on Instagram. Hello. Shout out to everybody, all my friends on YouTube, Facebook, Instagram, TikTok, LinkedIn. Great to see each of you. Neira, good to see you. All right, I see you. So, all right. So, there's motions. There's motions that you can file in court. They can change the game. All right? Each motion has its own rules. Each motion has its own filing procedures. If you have questions about it, see the EOIR practice manual. EOIR is the Executive Office of Immigration Review. It's the office within the Department of Justice where all of the immigration courts in the United States report to. All right, and they have a practice manual, and Chapter 5 of that practice manual is dedicated to how to file motions. All right, like you can do that. All right, each motion needs to be served on opposing counsel. All right, they need to be served on the proper office of the United States Department of Homeland Security. All right, the Office of Chief Counsel for DHS. They are our opposing counsel. They're the attorneys that essentially are trying to deport everybody. All right, and so they're the bad guys if we're in immigration court. And so we're talking about motions in immigration court, and you wanna know how to use them. All right, after you file the motion, a court will give them, DHS, time to respond to it. They'll typically give them 10 days. All right? And so after that, depending on if DHS does respond or if they oppose it or something like that, you can reply. There's sometimes there's written arguments that get sent back and forth in these things. Okay? Sometimes a case can be won or lost in the motions that somebody files to immigration court. All right, so let me tell you a story about that, okay? Once my office had a case where DHS, Department of Homeland Security, put my client into deportation proceedings, and they were arguing that she committed marriage fraud. Okay? You married a U.S. citizen. That marriage to a U.S. citizen was a lie. It was fraudulent. That's what DHS was arguing. All right? But the only evidence that DHS had of that was one signed statement from her ex-husband saying that she married him solely for immigration purposes. Now, why would an ex-husband sign that document? All right? However, in this case, we got to work and we got evidence that immigration made her ex-husband sign that, or at least he felt like he was forced to sign that document. They showed up at his place of work. They put him into a back room. They said, here's a document. We need you to sign this document. That's the way it went down. That's shady, all right? That's shady work of the Department of Homeland Security, and sometimes stuff like that happens, all right? So my firm filed a motion to suppress that piece of evidence. And you know something? The judge agreed. They suppressed that piece of evidence, which happened to be the government's only piece of evidence that there was marriage fraud. Then the judge terminated the whole case, right? And that client is now a United States citizen. Got it? Like, motions like that change the game. And that's just what that's really what I wanted to make clear today, okay? Like, when a person is in immigration court, you don't want to just let the court process drag you through it and not think of strategies, think of ways where you can file things to your advantage. You want to take, this is a court process. You have the right to make your requests or to show your side of the story or to ask the judge to consider your evidence, right? And you can do those things. You can use motions to your advantage. Sometimes doing that can completely change the outcome of the case in your favor. Okay? That's my point today. I hope this was helpful. Hope it was useful. It's great to see everybody. Now I want to get into your questions. If you have questions, send them over, and I'd love to answer them. Okay? So, and if you're just tuning in, I'm Otis Landerholm. I'm the founding attorney here at Landerholm Immigration A.P.C. All right? We're a law firm in Oakland, California. We fight for the rights of immigrants who are facing deportation. And, send me whatever questions you have. I'm a big believer in filing procedural motions in immigration court to maximize our clients' chances of winning. All right? Put every argument you can in front of the immigration court, because it's typically your only shot when you're in that, and so stakes are high. So you don't want to leave any stone unturned. You want to take advantage of anything, any way that you have to fight and to present the best arguments for you. Okay, so let's see. I've got a question here from Nguyen. All right, Nguyen, thank you for asking your question. You say, if I got my oath ceremony notice mailed to me through the N-600 form, do I need to study for the test? Well, first of all, Nguyen, congratulations, all right? And the reason I say that is if you got your oath ceremony notice through through the N600, you've basically won. All right, that's basically the approval notice. You, if that's the situation, then go to your oath ceremony. All that's going to happen is you're going to get sworn in to become a U.S. citizen. All right, so huge congratulations to you. If that's what you got, you do not need to study for the test. The N400 is the process of quote-unquote naturalizing, and there you've got to go to an interview and you got to take basic English test, your history and civics test, right? The N600, on the other hand, which is what you're saying, is a request to demonstrate that you either acquired or derived U.S. citizenship through your parents, okay? And so in that situation, you've already, if that was approved, if it was an N600 case, you don't need to do the tests at all. All right, got it? And so if that was approved, congratulations. Go to that oath ceremony. After your oath ceremony, you will formally be a United States citizen. You can apply for a U.S. passport, do all that good stuff. Huge congratulations to you. Okay? The next question I see here comes from Shanmuganathan. Shanmuganathan. Did I say your name right? That's a very cool name. Shanmuganathan. Very cool name. Thank you for asking your question. And you say, according to USCIS, I have overstayed my visa and the case is with an immigration judge. The next hearing is in January of 2024. What will happen to me? Okay. Well, Shanmuganantham, I enjoy saying your name. And what will happen to you is you'll be sent a hearing notice for your hearing in January of 2024. And I highly recommend you hire a lawyer well before then so that they can represent you and give you good advice about what the best strategy, what the best option, what the best arguments will be to present your case in immigration court. All right? That's my best advice, you know, and if my office can help you with that, hey, we'd love to help you with that. The way to do that, give our office a call. Everybody that calls our office gets a free 15-minute evaluation on the phone of their situation, all right, with my intake department. And then, you know, if you want and if it makes sense for you, you can schedule a consultation, which is paid. But our paid consults right now have discounts because of the holidays and things like that. So now would be a great time, and we'd love to help you. Okay. So let's see here. Naira, hello. You say, could you please save your live? So absolutely, thank you. Our lives are always saved on YouTube. All right, so check it out on YouTube. Vinod, I see your question here. You say, hello, sir. Good afternoon. 3 months back, there was a robbery that happened in my home. My goodness. And we have a case report. Can I apply for a U visa for this incident? Wow, I'm sorry that that happened. Vinod, I'm sorry that that happened. The answer to your question is it depends. All right? Robbery is not an automatic qualifying crime for a U visa. Robbery is it can count. See, if they charge it as just a crime against property, right, where no person was harmed or threatened, then it doesn't work for a U visa. But if they charge it as like maybe if you were there in the home and if the robber like held you up at gunpoint, or if the robber said, hey, freeze, or something like that, and you're stuck there in your home while they're robbing you or something like that, if that's the situation, then that's a case. All right? Yes, that would be a case that I mean, I'd love to take that case. All right? It's not, anyway, U visas, the way that the first step for you, Vinod, is to ask the police department to get you a copy of the police report and then look it over with a lawyer. All right? And if my office can help you with that, give my office a call. We'd love to, you know, we look at U visa police reports, very frequently, and we could just do a full consultation for you, and we could get you good advice, whether it's the U visa or something else. We can help you navigate your immigration situation. Okay, so Vinod, best of luck. I'm sorry that you went through that. That is all the questions that I've received up to this point. All right, any other questions for today? All right. All right, you guys. Well, thank you all so much for being here. I really appreciate your being here with me. I'll wrap up, and then I will do this episode also in Spanish. So if you speak Spanish, join me in just a few minutes, and we'll do it in Spanish. In the meantime, I always like to say that if this information was useful, if you want more information, please subscribe to our channel in YouTube. Just hit the subscribe button, right? You can also click the notifications bell in YouTube, and we can get you additional legal updates and news. It looks like I did just receive another question. Bear with me. It's from Ramji. Hello, welcome, and thank you. You say, I have a removal since 2003. Motion was denied in 2004. Maybe a motion to reopen was denied in 2004. I've been married to a USA citizen since 2007. I have kids. Can I try to file a motion to reopen, get a new decision, and will a new decision by the Attorney General help my case? So Ramji, thank you so much. The best advice for you in your situation is step one. Well, step one, let's do a consultation and figure all that stuff out. But really, the first step after that is let's request all the records. All right? When it's an old case, 2003, 2004, almost 20 years old now, let's request all the records. Let's really see what caused the case to get denied back then. Maybe there is an argument to reopen it. All right? So so I hope that was helpful. If you want more, give my office a call. I'd love to really look at it with you, okay? So the next case I see here now is Makan. Makan, hello. You say, does an I-730 motion to reopen guarantee? Does an I-730 motion to reopen guarantee? So let me. I think there's some confusion there, Makan. An I-730 is a petition from an asylee. A person has to have won asylum, and now they're petitioning for their spouse or children through the I-730. That's what the I-730 is. It's not a motion to reopen. Okay? So an I-730 is if you win asylum, you want to petition for your spouse and children. All right? If that case was closed, could you reopen that case? Theoretically, yes. Does it guarantee anything? No, no, it doesn't. All right? I hope that was helpful. If you have additional questions, please call my office. We'd love to help you. All right? That's all the time that I got for today. Thank you all so much. Again, please subscribe to our channel in YouTube. Hit that notifications bell. Give us a thumbs up if you thought the video was useful. Those types of things, they help Google understand. They help the internet understand, that content is useful content, right? And if you have an immigration case, hey, please give us a call. We are here to help. We would love to help. All right? Thank you all so much. Hope you're doing well. Have a great Tuesday, the 13th of December, 2022. Make it great.